In this presentation, we will talk about open data licenses. We will discuss two questions. What are the promises of open data licenses for user-driven open data ecosystems, and what are the challenges? To understand why open data licenses are necessary, we have to start from intellectual property. While ideas and facts are free for everyone to share, creative works like books, artistic creations, and data sets are the intellectual property of the creator. In the European Union, a data set can receive two types of intellectual property protections. One, the structure of a data set can be protected under copyright, and two, its contents can be protected under the sui generis right. These intellectual property rights limit how existing data and information can be compiled into a data set, as well as how a data set can be further reused. Intellectual property rules create a producer-driven data ecosystem, where the creators decide how their creations can be reused. To move to a user-driven ecosystem, the open movement started in the early 2000s. Central people in this movement were Richard Stallman and Lawrence Lessig. Stallman created a list of principles for free software which were incorporated into the open data movement. Lessig created the first set of open data licenses, the Creative Commons licenses. These two developments paved the way for open data licenses. These licenses are legal instruments that invert the logic of intellectual property. So creators provide pre-facto authorizations for reuse of their works to enable a remix culture, a culture where data and content can be freely used and reused. In this slide, we can see the key components of an open data licenses, which takes the form of a legal contract. First, it starts with a set of permissions that the creator grants, including the right to copy and the right to create derivatives. The creator can also add conditions like requiring credit or ensuring new works also remain open. Or the creator can use the public domain declaration to waive all ownership rights. There are many types of open data licenses. Creative Commons or the Open Database license are popular licenses for data sets. Countries like France and the United Kingdom also created their own licenses for open government data sets. In principle, open data licenses are a great tool to foster openness and create a user-driven open data ecosystem. But in practice, there are some practical and ethical challenges. We will now discuss some of these. One of the biggest practical challenges with open data licenses is uptake. Some laws, like the Open Data Directive in the European Union, encourage government bodies to release data sets under open licenses. But in other cases, use of open licenses is entirely voluntary and depends on the motivations of dataset creators. The other problem is choosing the right license. Currently, there are over 100 open data and content licenses available. And finally, once a license has been chosen, there is also the challenge of ensuring compliance by reusers. There are also ethical challenges. For instance, big data analytics come with the risk that personally identifiable data is either inadvertently included in an open data set or can be inferred from the data set. New technologies like generative AI also bring some challenges. Many models are trained on open data sets, but the outputs don't always respect license conditions of attribution and share alike. These create a tension between free reuse and responsible reuse of datasets. Creators need to make trade-offs between sharing more data for public good and in the public interest on the one hand, and balancing legal and ethical issues on the other hand. This is encapsulated in the principle of as open as possible, as closed as necessary. There are new license models for sharing data sets that might contain personal data. For example, two researchers have created the Open Data Commons license, which introduces a privacy pledge that must be affirmed by each reuser of a mixed data set. There are also new data sharing infrastructures that enable responsible sharing and reuse of personal data, such as the My Data project or Tim Berners-Lee's Solid project. When it comes to legal and ethical risks associated with new technologies, open data licenses can be combined with other legal obligations. For instance, the new AI Act, applicable to the European Union, imposes transparency obligations on developers of generative AI applications to disclose information about their training data. And finally, when it comes to compliance with license terms, we can look to case law developed by courts on open source licenses. You can see the names of some relevant cases on this slide. To recap what we discussed, an important aspect of opening data sets is ensuring legal openness. Open data licenses are the most common legal instrument to do so. But choosing the right license can be difficult. Here, the principle of as open as possible, as closed as necessary is useful. Further, for resolving new tensions with privacy, for example, data holders can look to emerging initiatives for collective licensing of personal data. And finally, open data licenses do not exist in a vacuum, but must work together with other legal obligations to ensure uptake as well as transparent data reuse. Thank you. Feel free to reach out for any questions.